I certainly commend it to the House.
In reply, Scott Simpson.
Mr Speaker, it's a great pleasure to be concluding this introductory debate on my Land Transport Admissibility of Evidential Breath Test Amendment Bill. And as various speakers in the debate have indicated, this is not a bill that is going to have an impact on a particularly large number of people. But the people it will have an impact on are currently able to literally evade the provisions made by this House in the Principal Act regarding drink driving, and they are literally able to get off scot-free. And I want to thank members for their considered debate, for their contributions to the debate so far. I'm very much looking forward to participating in the Select Committee process under the capable and very able chairmanship of David Bennett. And I know that once we get it to Select Committee, we will address some of the issues that have been raised in the debate so far. I was particularly pleased early on in this exercise, Mr Speaker, to receive from Mike Noon at the Automobile Association support in principle from that organisation. Now they too understand that there has been a very significant attitudinal change towards drink driving in this nation over the last, generation or so, since Dr Hutchison was practising medicine as a young intern, some years ago. Just a couple of years ago, things have changed a little bit. And so the society's attitude towards those who drive while under the influence has changed significantly, and for even a small number of people to be able to evade the intention of this House and bringing them to remedy for the consequences of their poor social behaviour and indeed their illegal driving, I think is a matter that needs addressing. And I want to just spend a minute referring, Mr Speaker, for the sake of those members who didn't hear it in the original speech, the judgment relating to the case of Childs, or the police and Childs, heard in a Rotorua District Court just this year, in fact in July of this year, where Judge Mackenzie examined all the current case law and had to dismiss a case against Childs who had blown a screening test. That's the one where you've got the little electronic device where you have to give your name and address, and he proved positive on that, and then blew an evidential breath test, and then was given the option of the blood test, which he is perfectly entitled to take under the existing law. However, Mr Childs was an intravenous drug user of some long number of years, and his veins, he knew, I suspect, were utterly unable to be tapped for the required sample of blood. And so after 40 minutes, Mr Speaker, of attempting to draw a significant and appropriate blood sample, the medical officer was not able to do so. And when the case came before Judge Mackenzie, he had to actually throw it out, because the situation in which the facts presented meant that Childs was statute barred from being prosecuted because no blood sample was available to him. I think that's wrong, sir. And even if it is for a small number of people each year, it's still wrong. And for this House not to address what was actually an oversight in the original legislation, in the original 1998 legislation, I think is something that we need to turn our attention to now, and thus the measure of the bill. So I want to thank the originator of the bill, my colleague, the Senior Government Whip, Michael Woodhouse, who did indeed draft the original bill, and I'm sure I can vouch for his grammar and the accuracy thereof. He has a good education. The Attorney General's report is something that is worth a small consideration, because the report does sit on the table of this House, Mr Speaker, but like other speakers on this side, I respectfully reject the position that the Attorney General has taken on this matter. It will still be the case of the police, as in any criminal matter in our jurisdiction, our criminal jurisdiction, to prove the case beyond reasonable doubt. That's the measure of all criminal convictions in New Zealand, and nothing would change under my bill. Now, the AA, in their support of the bill, have indicated that they too would like to consider narrowing the clause a wee bit, and that's a matter that will be rightly and properly addressed at Select Committee. And so I'm looking forward to participating in the process so far. I thank members for their consideration so far and commend the bill to the House.
The debate having concluded, the question is that the motion be agreed to. Those of that opinion will say aye. Aye. Contrary, no. No. The ayes have it. Party vote. The clerk will conduct a party vote.
New Zealand National.
59 votes in favour.
New Zealand Labour.
34 votes in favour.
Green Party.
14 votes opposed.
New Zealand First.
8 votes in favour.
Maori Party.
2 votes in favour.
Mana.
1 vote opposed.
ACT New Zealand.
1 vote in favour.
United Future.
1 vote in favour.
Any other votes?
The ayes are 105 and the noes are 15. The motion is agreed to. So the
Land Transport, Admissibility of Evidential Breath Tests Amendment Bill, first reading.
The question is that the Land Transport Admissibility of Evidential Breath Tests Amendment Bill be considered by the Transport and Industrial Relations Committee. Those of that opinion will say aye. Aye. Contrary, no. The ayes have it. Call on members' order of the day number 2.
Conservation Natural Heritage Protection Bill, first reading.
Jackie Dean.
Mr. Speaker, I move